The beams,
The
I guess.
beams, the joists,
Trusses, you told them. They were center trusses, weren't
maybe they were.
they?
And
Was that the center trusses that were separated?
Yes, it was the several trusses together.
you should answer that question.
Yes, sir. What are the trusses that need to be brought airtight?
So basically, it's the multiple truss arrangements when you first enter these.
Okay, so that's what we thought.
All right, we're good.
Now, fine. There's a wrinkle in that you ought to be aware of that we'll bring up in a second. The third category has been this sort of ongoing debate that's been going on for a really long time about tar coatings for the truss plates. My understanding is that the building drawings all show that stuff needing to be coated. That the first time that the salt shed was put up, the contractor did in fact coat all of those things.
Not the truss plates, just the purlin bracket.
They didn't do the coat?
We never raised the trusses.
Oh, okay. So he did the purling brackets, but the trusses never got raised, so they didn't do that. And then when we subsequently did it again, as near as I can figure, none of that was done. Now, in the middle of that, there was a discussion between Mid-Hudson and you guys, Radco, about whether Lester could coat them at the factory. That discussion involved a change order that was discussed but never fully executed. That would say they would coat them at the factory and that they would charge an extra, $8,000 or some amount of money for coating it. But even that change order acknowledged that they would still have to be touched up when they arrived at the scene to make sure that they were fully coated before things went out. The truss plates were coated at the factory, but they were only coated on one side, and when they arrived, they were pretty scraped up as well. The contractor, meaning Mid-Hudson, said that he was rejecting the plates and not going to pay for them because they weren't done in a completed fashion. Lester/Radco agreed with that, and so they were never, that cost of that was never passed on to them from Lester. But somewhere along the line, the Mid-Hudson saying that the plates weren't adequate and they weren't going to pay for them resulted them in the construction going up without them being coated at all. And that has been a concern of ours since the beginning, since these things are in a high corrosive environment, and we're concerned about the truss plates as well as the purling brackets not being coated according to the drawings. I noticed that I don't believe that was really addressed in the report, other than to say that they had been coated at the factory, but that coating was not adequate, as acknowledged by both us and by Mid-Hudson, frankly. And so, from my perspective, that is also a major issue of outstanding work. So, the two big items, to me, are: do the brackets need to be coated? We believe that the answer to that is yes. And if so, who's going to do it, and how much is that going to cost? And the second one has to do with the entryway and drawing those beams together. Now, as I said, there's an added wrinkle to that, which I'm going to ask Al to explain, because there's a story behind those particular beams, or trusses.
All right, just real quickly, obviously what happened, the reason why the plates got done, the purlin brackets got done once is Lester delivered the first set of trusses, which was 8 or 10 truss them. The truss plates were not rolled correctly. It never happened before, but the truss plate machine broke. It happened to 3 jobs. I already brought it up the first delivery. Mid-Hudson accepted them all, put them together, and then asked for a certification. And we failed them, obviously, as soon as we knew what happened. So they had to be taken apart, put back on a truck, sent to Leicester. When that happened, Leicester said these things look like shit. They've been out in the weather. They threw them in the garbage, built brand new ones, and delivered them by November, I think it's 2000. Actually, yeah, it was November 2000. They were left out all winter and they didn't come back until the spring. Their managers at that period quit. Their 4 job foremen were fired. So basically, the job was kind of in disarray at that point. When the coatings came the first time, those trusses came the first time, they called me. The bid design drawing showed they had to do all the coatings. There was no tar done at the back. They called me. So the first thing they did, I have them right here, which I'm going to give to you in emails. They did notice immediately that the purlin brackets were not in the original drawing. They were in the final design build drawings, which, yes, they could have charged if they wanted to. But at that point, we had a great relationship. Then Mike was giving them the fuel. He was helping them unload trucks. So it was really not that big of an expense. You just had a dip. I showed them how to dip when they did it, but they acknowledged they knew. So it was just a matter of if they wanted to charge. So they kind of stuck in. I got an email to prove that. So they did all the purlin brackets. The trusses went back. They never did the trusses. They changed managers 5 times. When the second problem happened, they assumed it was our fault and they put up all the trusses wrong. We had to fly an engineer out here, and our engineer wrote a report that it was their fault. Then they asked us how to fix it. Our engineer did a design to fix it. They cut the bolts, they'll go into place, they're designed correct. They did that. Then when it got to the middle, because they were double trusses, you couldn't do that. Mark Day emailed and said, how do we fix these? And frankly, our engineer said, listen, this is your problem. Buy 6 new trusses, and I'll ship them to you, or engineer something yourself. And he did so. He never came to the board. He's supposed to be working for us, but he designed a repair that I've been asking for a stamped drawing of for 2 years. He has not provided it to this day. I asked our attorney for it because we needed to sign off. Now you're telling me as the engineer that we got problems with that possibly. But we really need to see his stamped drawing design and if it was built according to that. We don't have that. Do you have that? I don't know, but we don't have it. And I asked him for that in meetings, and he said, you'll get it at the end. He obviously doesn't want to provide it. So my concern is if there's something wrong with the design of his repair because nowhere else is things splitting apart. So that's really, you would agree, that would be important to get his design drawing because he just took it upon himself to do that. So that's a huge concern that we get that. And I was like, it's got to be verified. Whatever he did is acceptable to you as an engineer. And was it built to what he drew? Because now you're telling me it's separating.
Yeah, what our engineer has been telling us is that he'll provide the stamp drawings as part of closeout. And number one, I don't understand if he's our engineer why I have to ask for stamp drawings, and that's up to him instead of me. But more importantly, if it's a redesign of something that wasn't included in the original approved design of the building, then, and we're having issues with it, it seems like that review has to take place before we could decide anything at all. I mean, the recommendation is to draw it together, and I understand that, but I think I'd like somebody to take a look at the overall design and just make sure that that's all that needs to get done. Unless you're comfortable with it working fine as long as they're drawn back together. Is that something you're confident about without looking at the diagrams?
Is that question?
Yeah.
Yes, Tom.
Let me just answer that. So looking at the trusses themselves, they all appear to be, manufactured in accordance with the design drawings. Okay. The only thing, again, that I can just notice is that I can see daylight between the sides of the multiple ply truss arrangement. From my perspective, from a structural standpoint, having them independent like that, they are still connected with through bolts or lag screws. But typical industry standards is if you're going to have a built-up arrangement like that, that they're drawn together so that it's acting in unison as one unit. Right now, they are in kind of a quasi in unit, okay? Because yes, they do have fastening or fasteners going through them, holding from lateral separation, which is horizontal separation, but they are still somewhat quasi-independent of each other. So, simply put, if they're drawn together, from my perspective, looking at it, you should be fine with regard to the overall design. I didn't see anything on the exterior wall system or roof that showed any signs of a wave or deviation or deflections of the roof, decking, etc. So that's, to me, it's just saying, it needs to be tightened up. So it's from a relatively straightforward process here. But what I would like to do is I'd like to kind of just revert back to a couple items here that I hope can answer maybe some of your questions with regard to the three categorized components there that were just laid out. The first one, the category one, yes, reading through that punch list items, it's all basic information in there to be wrapped up, really. I agree with you guys on that, and for the most part, there really wasn't a structural review on most of those components, the majority of them that were presented in that, so it was really more just kind of a punch list to wrap up the overall process. The second thing we just talked about was the separation of built-up truss. But the third thing with regard to the epoxy tar coating arrangement, one thing that I did not see in the drawing was a specific thickness to the coating. Yes, they do call out for it to be on there, and technically it's on there, but there's nothing saying it has to be applied to a specific mil thickness. So this is a tough situation right there, because the epoxy tar coating is there. Whether it's been scraped or whatever, they didn't come back and put it on, but for the most part, they looked pretty decent. So when I look at a metal truss plate, number one, it's it's either electro galvanized. Now you've got an epoxy tar, full tar application, and then you have this whitewashed coating. So in theory, you have three coatings on each metal truss plate. So I think you guys are protected. The other thing is, when you say that it wasn't provided on both sides of the plate, I don't necessarily know that you could technically do that on the fastening side of the plate, because the fastening side of the plate is basically prongs. And those prongs get pressed into the timbers. So all of the design information that I'm aware of is based on essentially a bare steel prong or an electro galvanized prong arrangement. You put another coating on that, you may have voided the way that the Truss Plate Institute had designed and approved that type of a construction arrangement for those types of trusses. Not to mention, from our standpoint, looking at it, if those prongs are embedded into the timber, well, it's protected as is. So, I think you guys got to kind of just think through this process with regard to really holding the feet to the fire on this coating, because there is no specific thickness applied on the drawing.
You're correct, but if you look at you have an engineer report that Lester did when the trusses failed in color.
Okay.
In that, you can look and you'll see truss plates where they attach to the brackets. I don't think they had to specify thickness because that coating is so thick. It's a very thick coating. It's almost like tar.
Yeah, but you can't put it on the inside is what he's trying to say.
Okay, and I went back to the manufacturer.
From my inspection,
Right.
that was performed, he wanted to know if there was a cold tar applied. And from my review, It appears as though it was. Now, whether it's obvious that it wasn't field applied, because otherwise it would have been, you would have had a lot of overshoot or
Under the wood.
design condition that would have gone, onto the actual.
Right, we all know that they didn't do that, and that the thing is, even Mid-Hudson themselves, and I have an email, it was a change order done by me. He called and asked me if we could do the epoxy coatings in the field. I didn't even call the engineer, I called the factory. I didn't even know they did it as a change order, obviously, because I got to pay it, that's why they did a change order. Mid-Hudson themselves rejected the change order and said, we're not paying for this, we got to do a ton of touch-up. So they themselves rejected it and then didn't do it. I disagree with you in the part that rust is rust. If you leave metal unexposed, encapsulation is what's supposed to happen, whether you do it with a spray gun or whatever, and I told them they had plenty of options. Even the manufacturer agreed, if it's not encapsulated and edges are done, rust starts just like on your car frame. If you got a little bit of rust starting on your car frame, it's just going to eat its way, peel the rest of it back in rust. So they themselves agreed it did not pay for that change order. The purlin brackets, they did the first time. Yes, it's true, it wasn't in the design build drawing. They acknowledged that I have it in emails, and they did it the first time. They knew they could charge for it if they wanted to. They didn't, because we did a lot for them, they did a lot for us. But they were well aware it wasn't in the original design drawings. So basically, they took back half of them, which weren't touched up, and then the whole right side of the building didn't get any of them. They're not even touched at all. Lester doesn't give any kind of warranty on corrosion. I mean, I did a little research. I mean, listen, it was brought to their attention in detail how important that this coatings were. And then they dropped the ball. It wasn't a huge expense.
The building is specifically designed for self-burn structures, correct?
Yes.
I mean, it's not like this is the first one that they ever built.
They didn't design this building. Let me tell you how this happened. This building is an alternate design. I did this job several years prior. The town of Lagrange hired a salt-built company to design this. Lester just had a bid as an alternate. We never did these coatings before. It was on the alternate design drawing that we bid against. And then I ended up not doing the job. Their plans had some issues, and the town used my drawings, and I didn't bid it again. So this coating design was not Lester's.
I'll provide my take on it. You folks, you engage me because I'm a construction attorney. It's all I've done. Okay, 25 years all I do. Construction law. I will tell you my view on it, and it has not changed considerably. In a court of law, what's going to matter is not these various things you're talking about. Maybe they have something to do with that. That's all questions of fact. You go through discovery, you go through lots of depositions. You pay a guy like me, which I'm happy to take the $250,000. Believe me, I'm happy to do it. And I will take that and defend your claim to the best possible I can. It will not be easy to do. You have 3 engineers now that have all said that the coating is fine. You have Day, who never made any mention whatsoever in any punches I've seen. You've got Hemlick's got the email. His letter comes out back to Stenger saying it's not required. What's out there is fine. No, I let you talk. I've got to speak. And then you went outside, which is, I applaud you. Your due diligence is phenomenal. And I don't mean that in any way, I don't mean it. It's true. You guys are doing your job. It's due diligence. And I understand you have taxpayers that count on you for that. You've done it. You've now hired a 3rd engineer who's come out with a professional engineer who has now come out and looked it over. He's told you it's fine. You've got 3 professional engineers that told you it's fine to do. Now, if you look at what the contractor's job is to bid, he has to build what's in the bid documents. That's what he's got to build to. Only thing I saw was a note on a drawing saying field apply some coating, epoxy coating. There's no spec, there's no material, there's no mill. There's nothing in the spec that tells him what material to get, or what mill thickness to use, what the application should be, or anything else. There's nothing in the spec that says that I saw. So now you've got 3 professional engineers, including Lester's own guy, saying it's not required. You've got a situation where I see where the field coating application, last document I saw was it August 19th, either 2019 or 2020, that change order you were mentioning, Supervisor, that was signed not by Mid-Hudson, that was signed by, I believe it was by you acting as agent, I assume, for Lester. So the only one that agreed to any of that piece of paper is Lester. No, Mid-Hudson didn't agree to any of that stuff. So I'm just saying, from a legal standpoint, whether or not you think they should have done a better job at that or anything else, I don't think it's a very strong position for you to, because you're going to come in and say, they're going to have 3 professional engineers, they're going to say it does require it, plus the one they hired. You're going to have to go out and find another engineer that'll say what you want him to say.
We got that. We got done it before.
Well,
No.
then get as many as
No.
you want. Find it. No, I'm not going to argue with you.
All right,
Yeah, you are. You're trying to cut me off.
Okay.
So what we have is this. You've now had this engineer come in. He's come in. He has no dog in this fight. He has reviewed your beautiful building. He has told you get about 25 or 30 grand, okay? Maybe it's 60 grand. Let's say it's 60. All right? So say it's 60 grand. Double what this PE told you it's worth. You're holding $374,000, okay? What could at the most be 60,000 grand. It's probably more like 20,000 bucks, okay? Now, the other thing I hear is that people want to go after the bonding company. The bond is not an insurance policy, okay? That's not the way it works. Sureties do not lose money as a rule. What they don't lose money. What they do is this. If you want to call the bond, and this is what you have, it's an A312 bond. You have to first give them notice of intent to terminate, okay? Then both sides have a chance to have a meeting if they want. You don't have to have the meeting, but if you do, you do that. Then you have to actually terminate that contract. You have to terminate it. Then the bonding company can, with your consent, bring Mid-Hudson as a completion contractor and do whatever you think has to be done. Or they can put it out to bid and say, this is work that has to be completed. Here's a bid to do it. Okay? And, or they can say, you know what, we're investigating. We think you guys are wrong. We don't think we have any obligation, and you can come sue us if you want to. But the bottom line is this. You got to give them the 374 or make it available to them. So that contract balance has to be put towards doing whatever work has to be done. And then when you spend that money, all I'm saying is I hope that you'll be able to then prove that Mid-Hudson was contractually required, okay, to do that work. If they're not, that's on your dime. You have to pay them too. So what I see here is this, and I've said it from day one. Finish the work that your engineer from Syracuse came down and looked at it for you. Go tell, and I do this. I go to Stenger and say, listen, Stenger, here's the deal. We'll give you 200 grand, whatever you want to pay GD off. We're going to hold the other 175,000 bucks. You get this work done, or by some date certain. If you don't, we're going to bring somebody else in and have it done and back charge it. And that's the end of it. And we all go home. You can talk about the tar coating if you want to, and you can keep bringing it up all you want. All I'm telling you is 3 engineers have looked at it and disagreed. Now you say you have another report, then bring that fellow in. Then let's have this woman or man come in and tell us what their report says. This thing is
wasting money.
I think you're in a very weak position to try and defend us against these guys.
What about Mark Day?
Mark, well, I don't know, but I haven't looked into Mark Day's whether he owes you anything.
No, not Mark Day. What he owes, I gave you, I don't know if you received it.
Mark Day what? What
His
is
conflict. Did you see
Oh,
that?
yeah. No, I agree. No, there's issues there, no question. And I did, no, you're 100% right. They never should have done what they did. They should have disclosed it, without a doubt. The only thing that I looked at was this, is that, okay, I'm assuming that was the wrong thing to do. How were you guys hurt? I'm trying to figure out how we hurt. Hold on. Because at the time he did that, I thought the drawings were all done. He was probably still managing the project for you.
6 months before it got started. Basically, what are you going to guess?
Okay, so you had that. So, but I don't see how you were, I don't understand what prejudice you had. What
He
injury?
didn't do anything. He didn't expect anything to do anything. And then let's go, but wait a minute. Then in this report, it says, that's huge because that means Mark Day's out. So you don't have 3 injuries.
Okay, I got 2.
Okay, so Mark Day's out.
Including Lester.
Lester said it both ways. They're in a big problem right now.
Okay, so that's what you got to depend on. Lester's your basis of design. So your basis of design guy comes in and says, oh, was this required? Yes. Well, how come this letter says it wasn't? Oh, it
I can
wasn't.
tell you why.
Was it what? Oh, well, you can tell me why, but I'm going to have, if I was an attorney and I have that look at me and I'm going to get it, discovery, I got the basis of design, engineer telling me, no, that the coating's not required.
It's not required, but they don't do rust. There's nothing in the warranty. Nothing. I asked him, I said, if it rusts next week, are you going to cover it? He said, no.
We also talk about material that's already galvanized to the highest level it can be.
It's not galvanized. It's not galvanized to the highest level. No, it has a galvanization, but that's not a great galvanization.
It doesn't.
That was the reason for the coatings. And again, it wasn't Lester's design. But Mark Day's a huge issue here.
Well, okay, but before we get to Mark Day, I'd just like to stay focused on Mid-Hudson. Because at some point, they don't want to sue us. Because if he did, he would have sued for a long time. He doesn't want to pay the attorneys. I don't blame him. But at some point, you're going to force his hand. The subs are going to start going after the bond. Now, this is the way the bonding company doesn't lose money. And you probably, if you're in the business, you know this. They have it called individual indemnity agreements, personal, right? You have to sign those. So unless your company's really, really well set up and been around for a long time, you and your wife or husband are now personally liable for anything that the bonding company has to pay, okay? So once the bond claims come in, then all of a sudden the urgency goes ramped up for Mid-Hudson. Now they have to sue you because otherwise they're going to have to, they can't have payment bond claims coming after because the payment bond, the surety comes after them and they got it personally. So now you motivated them. They have no choice. They're in a corner. They must sue you. At this point in time, they're not looking to sue you. I mean, I think that I could get Stenger to do this work that we're talking about without even fighting about it. Finish the work up, which may or not, it's $30,000. Okay, you want to argue about $30,000? Go ahead. To me, it's not worth it.
The town board offered a month ago. Didn't the town board say to go to Stanger and say, finish the coatings, do the...
No, not the coatings. I'm talking what the consulting engineer you hire at Syracuse, the work items that he talked about doing. The coatings to me are you have so little chance. On what basis? Where is it in your contract? Tell me how they're not. Because you got one note in the drawing with no spec on what has to be done or anything else, and then you have a change order in August of 2020 that Lester signed, where it appears to me they took on the responsibility for a bunch of. I don't understand the whole.
Explain how it happened.
No, I don't need to know. All I need to know is that somebody signed that, so that obligation now is transferred over. Somebody else has picked that up. For some reason, why they felt it was necessary to do that, there must have been some consideration, which we'll have to figure out later. But Lester picked up the obligation to do it. Which, okay, you can tell me again, from a legal standpoint, you now have all these defenses that Mid-Hudson has. All kinds of defenses they got coming at you. And you want to hold $375,000 and tell them, without a doubt, you have the obligation to do that. I haven't seen it. I haven't seen it from day one. I still don't see it.
I was trying to get this. This coatings will haunt us if they're not done.
You said. This engineer says no. Your guy says no. From Lester says no. And they didn't.
No, he just says no. What he said was.
I got the letter.
Yeah.
And his letter says it doesn't prevent you from getting the warranty, but our warranty doesn't cover
It's not required. That's not what it says. It's not required.
It'll have to be maintained. You have to watch it every year.
Anyway.
So what?
You always got to do that.
If it's coated, it's a minimum of 30 years.
Make a motion.
It's total.
We vote?
No,
Why not?
this is not a meeting.
All right, well, I want to have a meeting.
Anyways, that's my view. I listen. I just want to let you know, you hired me. I've done work for you guys. I've done the best I can to figure out what's going on here. I deal with these kind of things a lot from both sides. Contractor and owner. I'm just telling you, this is one that should be resolved. You've got plenty of money in the till to get it done. I think you've got a contractor that is willing to do something rather than sue. That's my take on it. Every conversation I had with Ken Stanger has been that way. And I think you should right now get a deal with him and get him to get up and do everything he has to do. Like I said before, give you all the lien releases you need. And if anybody he can't get released from, tell him he'll bond it off or guarantee or whatever. And have it done. And be done with it. And move on. And let him pay all these subcontractors. That's my view. I haven't seen it. I don't see it.
Hey, Reg,
Yes.
you have anything you want to say?
No,
It's been
actually.
awful quiet for you.
Oh, I know, but you know what? This thing, it didn't have a building permit day one. Mark, they put the fire code up. Ken said that he didn't approve it. Mark said it was approved for the firewall. So, you know what? As far as I'm concerned, I trust the engineer that's talking right now. And I mean, granted, you know what, we're gonna have to watch for rust and corrosion, but we're gonna have to do that anyway. And to do all the coatings and everything again, I mean, I don't feel that we're gonna get another 30 years out of it. If we get someone to go up there, if there's a spot that has to be hit once in a while, we go up there and hit it. I mean, I just think we're kicking a can down the wrong road, and we're gonna end up being sued for something. And like Adam say, I don't think it's worth it. We did a lot of stuff wrong. A lot of inspections weren't made by the building inspector. I mean, there's a lot of stuff that I would have called the bonding company a year ago when that stuff started going bad, when they were putting up moldy plywood, and when they were doing a lot of things, we should have never whitewashed it. There's a lot of things that shoulda, coulda, woulda, and I mean, I don't know what anyone else's opinion is, but I'd like to hear from everyone else saying that, I just believe Adams that if it was said that Lester said that it wasn't needed, why would Lester say it wasn't needed? And we got just too much contradiction going on. We're fighting a fight. We're going to spend more money on lawyers and engineers and everything than when we would just let's give Mid Hudson one more chance. You come, we'll give him a list 1, 2, 3, 4, 5. Tell him to finish everything. Give him time to do it. And if he doesn't do it then, and if the building's not finished, then we have a leg to stand on.
So it sounds to me like you're agreeing with what the advice we got from our attorney was, that we should propose that they fix all the things that were in the latest engineer's report.
Correct.
And that's what you think too?
Yeah, I let you
Both of you?
some money first so they get cheated and paid so they can.
Yeah, I mean,
before the end of the year.
we do have subs that weren't paid prevailing wage. I mean, I know that. Are we going to go after everyone? I mean, we're going to. There was not a lot of oversight.
Payrolls for all the subs. Yeah, I think that's just a rumor.
Okay, well then, I mean, let's get a punch list. Tell him to get over here, finish up the building.
We have a punch list.
Okay, I can't fight City Hall. I just got one other comment then. I mean, I'm obviously if Rich wants to do it, I'm fine with it. As long as the board knows my opinion on it, I'm good with it. The determination, it says in here, that was worked out, the determination if the firewall met code was done by Mark Day and agreed upon by the building inspector. I asked the building inspector that question. He said to me, it's not true. The engineer of record made the determination. But if the engineer of record is compromised, should this new engineer determine if it was code or not?
Well, you could have make that determination if you like.
That's all I'm asking. That's all I want to be.
Okay, but he did look at the change order stuff, because there's some concern about the change order not being reasonable, commercially reasonable. He did make a determination that it was commercially reasonable.
So I just want to make sure it's on the record that, because this could get into a battle where, right. So I just want to know that you, as our engineer now, agrees that the way that's built meets code because there's no fireproof sheet on.
So Tom, I think what we're saying is, you know what the controversy is around the wall, whether it was supposed to be a fire rated wall or not. So it's right now as it stands, it's going to remain the way it is. And I guess the question is, do you feel comfortable that your view of the code, your interpretation, that is going to meet code?
Well, I got to step back a minute because the last that we had talked, that it was my understanding that whole firewall issue was resolved through the code enforcement officer. So we did not spend a lot of time focusing on that other than reviewing what the credit was going to be.
Okay.
And the way that I understand that firewall arrangement layout was not only because it was a vehicle storage area, but because of the fact that it had heating elements hanging off of the ceiling system. And if you look at on the drawings, they divided the two sections of the vehicle storage areas with a perpendicular wall system, and having one heating element on one side, one heating element on the other. So again, it was my understanding that was resolved because it went back and forth between a firewall first, and then it came out, and then it was, okay, we're going to put a fire retardant paint on there, and then apparently that was resolved or removed, and then there was a determination that it was fine the way it is. And so that's where we're at.
Okay, so and
The determination was
you
nothing
say
that can't work.
okay, so you're saying the building department.
He told me, I didn't don't put my name on it. He said, I didn't say a word.
Yeah.
I just accepted.
Well, I mean, there could be interpretation of the code. So yeah, I understand that
That's what
concept.
my only.
So is that something you can take a look at, Tom, or no?
We can look at it. I mean, it's basically a standpoint. It all boils down to area classifications according to the building code.
Right.
That's the thing.
Can we resolve this issue by adding the fire cutting to the list of the punch list?
Well, it'd be expensive. You have to put a whole new. You have to put a
You don't
wall
want
up.
to make these people do anything. I mean, yeah.
You'd have to go.
That's something. We're going to lose every truck we have and the building.
Yeah, I mean, that was Mike's fault for they said they wanted to.
I agree. Okay. Well,
Somewhere along the line, we we had a proposal, I think, from Mid-Hudson.
Hudson gave that proposal.
But didn't somewhere along the line, didn't we get a proposal to coat it with fire coating as well?
Yeah, and then Mark Day said it didn't need no more.
The wall's gone. The firewall's gone.
Now it's plywood, so it's kindling.
It goes just above the ceiling, I believe.
Right.
Yeah.
So the big question is,
the question is, should we ask fire coating? I mean, we're not going to ask them to take the wall down and put up one with double face, right?
I would just ask that the engineer look at this. Brian had laid it out with respect to the code sections, and as you said, it was a question of occupancy.
yeah, Brian's on the hot seat for accepting it too. Now,
Yeah.
Yes, we'll take it out. So,
that's
Tom.
all I'm asking at this point.
All right. So Tom, I guess my question is, do you have the information you need to interpret this, your own objective interpretation and come to your conclusion as to whether or not you think it's a fire-rated wall or should be a fire-rated wall or not? Do you have the information to make that determination?
We should, from the drawings and from what we saw out in the field.
Okay.
Yeah, because
Let me give you a back.
If I could just throw in a couple of things. This is where this gets all, we've mixed the paint and now we're trying to unmix it. And it's like you've got your own code enforcement officer. Are they making a determination? Are they accepting what's being done? You have your engineer originally that made a determination to that code enforcement that apparently indicated that it didn't need to have it. And was it signed off on? But then I understand that then the code enforcement came back and said, no, well, now we need to apply a fire retardant paint. So now it's like, well, which way are we going? It's like up or down is up. And so it really makes this whole area extremely confusing for everybody. And along the way, I don't see how you, and I know no one has brought this up yet, but with regard to the fire retardant paint, I mean, you certainly can't put that on the contract because there's nowhere in there is anything about putting on fire retardant paint. It was a firewall system, and that they gave you credit, or at least gave you a summary of what the credit would be for not installing it. I don't think you can hold their feet to the fire to put that on because it was never in the documents to begin with.
Yeah, but the coatings is a tenth of the price of what that credit should at prevailing wage. I don't know if you estimated, but I did. It was
Whether it's half of the price or
right, but if they gave us the $60,000 credit, you could have put it on ourselves, but we didn't get a $60,000 credit.
But at this point, just a heck of it, I'll take care of the legal. But if you could just tell me, Tom, from your engineering viewpoint, if you could give me your based on what you see, what classification would you say it should be, and what should it fall under, and then that might answer the question. If you come back and say, no, I agree with Mark Day, it doesn't have to be, then that's fine. Or if you say, no, my interpretation is whatever, and I think it should be, then we've got to deal with that issue, and then contractually we'll figure out who has to do it. But I think the supervisor wants to ask you a question too, so go ahead.
I want to give you a little background about what happened here, I think. The original, as Al said a little bit earlier, the history on this is that we put this out to bid a number of years ago, came back with a design, and that called for, and then we put it back out to bid with the specs that had been given as an alternate design in the first cycle. A town engineer was involved in that, and those specs had that wall in as a firewall and needed. In the middle of the construction, the Mid-Hudson came to our highway super and said that he didn't think that the double-faced sheetrock made a whole lot of sense in an area of high moisture, and that he asked him whether he could do it with plywood or something along those lines instead. Our highway super told him that it was okay with him under two conditions. The first condition was that it didn't cost any extra money, and the second condition was a Met code. And there was a discussion during that period with our building inspector regarding that wall being fire protected when it wasn't going to be double sheeted sheetrock. And I believe that's where the subject of, well, another way that you could make it, fire resistant is to use fire resistant paint as a suggestion of something that could be done. Subsequent to that, our engineer drew up a determination that said his reading of the fire code was such that it didn't need a firewall at all. I believe the rationale behind that had to do with requirements related to occupancy, since the building is not occupied space on either side of that wall. And I think that was the basis of his determination that it wasn't needed.
Okay.
I think it was Stokosa, but yes.
Mark Davis. Right. That's my issue, because our engineer who designed that firewall says it is code.
Now, I will say that I had a conversation with our building inspector about the apparent disparity between the letter from our town engineer that originally said that it was required and the engineer that we hired to review this project, which was a different engineer, saying it wasn't. And the response I got was that original determination was made a number of years ago, that the fire code of New York State has changed in the interim. And what surprised me is that it left more flexibility and more wiggle room rather than simply making it more restrictive. And that what our building inspector said was that the rationale and justification from what he refers to as the engineer of record, which is Stokosa/Day, was, he didn't say that he got it right. He simply said it's not inconsistent with the fire code. In other words, if he had made some justification and our building inspector had looked at it and said, yeah, that's not right at all, I think he would have called him out on it, and he chose not to. He simply said, well, that he's the engineer, he has the authority to do that, and bottom line is, it sounds like two tax attorneys looking at the same thing, and one of them saying, yeah, that's one way you could look at it. Right? That's the way it felt to me.
You would think the code, if you don't have looked at, you would think it's really exact and easy to follow. It's not.
No, I agree.
In some cases,
Correct. And that's all he was saying. He was saying, yeah, that's a way you could read it.
That could come out that he terminated, and the credit also, you did analyze the credit.
Yeah.
So
It's in here. It's in the report.
if I can just finish my thought.
Yeah.
That was a pretty long-winded story of what happened. I wanted to make sure Tom heard that, simply because I do think I'd like you to take a look at it and give us your own view on that. But I wanted you to know how we got where we are.
Well, I appreciate that. Thank you for giving me insight on it. Because one of the things that right off the top of my head here that I see that if there is a determination made that you do have to have that type of construction, double wall, drywall, and or double layer drywall assembly, not only on the ceiling, but it's the wall as well.
Yeah.
Basically, what you do is you're creating a encapsulated area. It's like a bathtub, if you can really think of it along that way, from fire. The fire can't penetrate anything through the ceiling or the wall. And where now you have potentially even more of an issue that you need to face is the fact that you've got a roof or a ceiling hatch, so that would have to go away, or it'd have to be a fireproof ceiling hatchway. The other thing is you have multiple penetrations through that ceiling for the hangers, for your salt beds. You have conduits, things of that nature. All those have to be fire sealed.
Yeah.
If it ends that route. This is not an easy approach from a construction standpoint by any means. And I don't, whether it's easy or hard, I'm just saying.
Oh, I agree with you, but that's why, there was a little bit, we knew that the paint wasn't going to be near as good as the double, but it was like kind of a compromise. But the question is, we just can't trust Mark Day's determination. The man is on the hot seat and has a conflict.
Where is your code enforcement
The
officer?
code enforcement officer doesn't want to make the determination, but I did ask the engineer who drew, and he says, in our belief, it's code. I agree with you. The code enforcer should have put his feet down and made a damn determination, but he won't, and he hasn't. Because I questioned him just the other day. He said the engineer of record did it, and that's it. He accepted that because he's the engineer of record. He will not make the determination. And I agree with you, he should have. I agree.
But it's my understanding, correct me if I'm wrong, from the last time when I was out there, that because of all of these things that have gone on over such a lengthy period of time, you still do not have a certificate of occupancy issued, correct?
Correct. Correct.
But you're using the building.
I'm sorry, what?
But you're using the building in all manners.
Oh, you had to. We were invited, the old Salt Shed collapsed. We were in emergency status.
I understand that. I'm just, this is Dan's bag right here on the legal side of things, but, you know, I would just kind of think that if something catastrophic happened to the building,
We're not covered.
you know, are you guys now left holding?
No, it's insured. They made us insure it, A, and B, just to let you know, they're 3 years out of contract at $500 a day penalty. The town has a lot of leverage here still if they want to take it. But it doesn't seem like the board does.
But I'm just saying that from the standpoint of.
Yeah, but we insured it. They brought that up and the town insured it immediately. The building's insured, correct?
Yes.
Right. So the building's insured.
Okay.
And,
If you don't have
on
a-
top of that, I had this discussion about the firewall with our insurance rep, so they were aware of it, and he said that we're covered.
So we don't want a firewall. If it burnt down in 10 years, we get a new roof.
You gotta know at least the code, Gary.
As long as there's no people inside, that might work out.
The only problem with these
You'll see
new
the insurance
trucks,
to come back if they figure it doesn't meet the code and see how hard it is to collect. And that was our other engineer's argument. I just want an engineer besides Mark Day to say it meets the code. Unfortunately, our code enforcement building inspector won't make the determination. I agree with you, he should have, but he won't.
You raised the issue of certificate of occupancy. A building permit is never issued.
They don't have to, right? It's a town.
Town does, or 12, 1202.
So maybe we have to issue one and close it out when we're done. They don't have any inspections about
Okay.
anybody.
can I just,
Yeah, you're compromised.
can I just say one thing about the new trucks and how hot the systems get because of this regen system and everything, and they are backing in to get into them sanders, and if they're warming up, I don't know if a spark's gonna do anything. I know it wouldn't do anything to sheetrock.
I checked with the fire. The fires are coming from shorts in the electrical wires. I told Mike we should put shutoffs on all the batteries. Because what happens is the wires get corroded on these newer trucks with all these computers, and they actually burn. You know, they short out. There was 5 fires in the state in highway garages last year or the year before from those damn trucks shorting out.
Yeah, I mean, if it was sheetrock, we would not be worrying about sparks hitting the sheetrock. But being as it is plywood,
If the truck ignites, think about it. Without a fire, I just want to know what's code. At this point, we can deal with the ramifications of it later. Is it code or not? That's all I want to know.
Question. The only thing I'll say, just to get on that, just keep the focus here, as far as us is concerned. Although they did, I believe that change order was executed with the credit and all, right?
By Mark Day, but if Mark Day's compromised, doesn't that put a big can of worms in it?
I mean, I don't know,
We're talking about the change order for that wall?
Yeah.
So Mark Day was executed.
I don't know if there was one officially.
Yeah, I'm not sure about
They
that.
didn't vote for it. No, they didn't do it.
I'm not sure that was ever
Nope,
officially
there wasn't.
executed.
The vote never
And
done it.
that's, by the way, that's why I told the story about the interaction with the highway super. The reason the highway super said it's okay with me as long as it doesn't increase costs is because if it increased costs, it would require a change order, would need to go to the town board, and he couldn't make that decision. But he felt comfortable saying is if it's not going to increase the cost and
And it needs code.
it meets code, then I don't really care one way or the other.
Again, it comes back to Mark Day.
I don't think, like I said, I don't think that was ever actually processed as an actual official change order. I think they proposed a credit as part of this whole discussion. I don't know that we ever processed a change order for
They
association.
didn't. Matter of fact, there was none. That came
So that's, in any event, you're gonna take another look at that and give us your thoughts, and that we'll deal with whatever comes out of that
Right.
after we're here.
And one other thing, just to kind of think about here too, that if it should come back that it is determined that it needs to meet the 2-hour requirement or so forth, you know, you've already got a lot of plywood that's up there right now. And I don't think it would be as simple as just adding more to it.
We know that.
Yeah, we know.
We know that it becomes a can of worms.
No, we understand that.
Okay. All right.
That's why we came up with the paint idea.
That's where the pain had come from, is because you'd be talking about reconstruction, and that's not realistic. So
Exactly. And then it's low, now you're changing things.
exactly right. Exactly right. All right.
And I just want to say that, you know, I'm fine. I just need that this board to understand me as my role as Lester, to understand my recommendations on coding, you guys, I'm fine with it. I'm not challenging it. I just wanna, to me, that is hugely important. If it comes back on us, well, no, right, if it doesn't, it doesn't. But I'm fine with it. Majority rules, it's fine. I'm not voting on this anyway. But this other thing with the code is huge, and whatever else you guys want to do is fine. But
it sounds like right now, Tom, it sounds like the board wants you to continue your investigation, but strictly on the question of whether or not the fire rating is required on that wall.
Will do.
Okay,
Good,
thank you.
and then, okay, thank you on that. All right, so we saw with Tom?
Yeah, we are.
Tom, thank you very much. I'll talk to you
Just one.
later. Are you good, Jim?
No, just one.
Hold on, Tom. Tom, hold on.
Regarding the final closeouts, I mean, with respect to, there's some issuance of the CRO or, maybe some, other documents that are required at the end, which
He should handle.
he should handle.
Yeah, okay, yeah, you're gonna handle the closeout.
He should.
Right.
Yeah.
Oh, I have one more question I want to ask regarding the discussion of the trusses that are separating. Shouldn't we be getting drawings so that
We need
somebody
that.
can take a look at those drawings to see whether?
And Jim?
Now, it sounded to me like Tom didn't think that was necessary. He said that he was comfortable with whatever solution he was proposing for simply pulling those things
Yeah,
together.
the binding that, there is a binding.
Correct.
About it. If there's a collapse, the only warranty we have left on this building because of all the crappy wood and everything went on is a structural one. If that building collapses under a snow load, you can't figure anything out. I need to have Mark Days to give the Lesters stamp drawing, and then you gotta just verify that's what he did, and we're good.
Hey, Tom, would you be able to, would you feel comfortable putting together a stamp drawing, 11 by 8 or something, like a SKI or whatever?
Well, I think there is one, because
We already have it.
I believe that Dave's DeCosta sent it to Lester.
Yeah, hold on, wait a second.
That's already done.
No, you hired a PE to come in and do a separate.
Oh, yeah,
You told me Days compromise, okay, you got a separate guy here, don't talk about, so Tom, can you put together some drawing with notes on it, telling the contractor what to do to correct the truss issue on the not airtight?
Yes and no.
Okay.
It's kind of a loaded answer question here. So the thing is, it's like, can they simply use the fasteners that are up there and draw them tighter? I just, from being at 35 to 40 feet below, I can't tell. If the through bolts, if it's a through bolt right now, you just get up there, put wrenches on and tighten down the nuts. If it's lag screws, it could be a little bit of a different piece because I don't know. I wasn't there during the installation, and is there potential for stripping of the lag? I don't know what it was drilled to. There's a lot of things here that are, I got to just be real careful with how I present it because it's an existing condition.
Okay.
Not something that we had.
So what would you need? Hold on. So what would you need in order to get the information you need to put out something, belts and suspenders fix here?
Ultimately, the right thing to do would be you got to take down the netting, you got to get a lift, you got to get up close to it and look at what they did. And then from there, you can come up with some better plan.
Okay, hold on a second. Is that something that you would have to be here for? Or could some, is that?
Yes.
Okay.
So, you would want it.
Okay.
Wouldn't you want to start with the stamp drawing that Mark did because that was his? Yeah, that's what I'm saying. So we need that, correct? He says he sent it to Lester. Lester never
Get that. But they're not going to. They haven't given it to us.
Yeah, I was under the impression because I have not got it and Lester has never told me they've gotten it. And we did ask for it. This is
to add to the whole mix here. It's my understanding that when they were putting those trusses up, that they did not, or they ran into an issue with regard to how they were erecting the trusses such that they didn't allow for the spread that was going to happen before they locked everything in, and they got everything out of whack. And you can tell by looking up there that there are open holes.
correct. You're correct. That's exactly what happened. But those were the ones that had to be. They couldn't be cut. How we fixed the others was cut the bolts and they went into place.
Yep.
Lester engineered that, but on those that couldn't be done because they're 4-ply. You know what I mean? You couldn't get to the bolts.
Well, exactly.
So I don't know what part they engineered. You need to if you're going to do the CL on this building, you need to say he did this drawing correct and the installer did it correct. Obviously, you didn't see everything, but we have to start with his drawing, which I've been asking for a year and a half.
What drawing is this?
But you can understand.
There was, when Lester, when they put the trusses up wrong, the thing was a mess.
Yeah, but
Lester came out and said, yeah, you did it wrong, it's a solar error. Then they said, can you tell us how to fix it? He goes, yeah, elevate the truss, cut the bolts.
Yeah,
when
but
you cut to the middle,
Yeah.
you couldn't cut the bolts because they're floor plat.
Rabco, I told them that day one.
Buy new trusses from us or engineer something yourself. Mark Day decided to engineer something himself without even asking the board, and we've never gotten design drawings.
And that's the problem. Those drawings will not match what the original specs
Right,
were.
it's some
And
kind
we
of a
don't have
concept.
updated drawings to
In other
look
words,
for
it's
anybody to
not a
look
concept,
at.
but it's not what we designed.
Okay, so Mark Day has re-engineered drawings for the truss installation.
And never given us the drawing.
Center trust, right.
Center trusses. It's the entrance trusses.
Yeah, I get it.
That's it.
Okay,
And that's the ones that's coming apart.
get those.
Yeah.
Get those.
Well, if I could just end on this, we gotta get those drawings, that's an absolute.
That's what I said, right? By law.
The second thing is just be aware that, and I know it's kind of common sense here, but we're not talking about, steel, we're talking about timber. So, you're drilling and you're removing material. And the more that you drill and remove material, the more you.
Well, that's material you have.
The integrity of this.
I've noticed, and I'm no expert, I'm no engineer, and I don't know, but I do notice on those trusses, they're only sitting in the brackets a tiny bit.
So there's a drawing dated, Dave's the posted drawing dated.
Because he's gonna basically open a building permit and give us a CO in a sense, right?
July 9, 2021, which redraw, it's called the salt shed truss bracket, and it's for the gang truss bracket.
I don't know if that's it.
No, that's a
We're
bracket.
not gonna solve that here. Just get us whatever those drawings are.
I'd like to try and look, okay, and that's a great point, and we'll get through that. I'm gonna get that Mark Day drawing somehow. I'll get it, and I'll get it over to everybody, but to you especially, Tom, and you can take a look, and then we'll have to set up a time when you can come down here. We gotta get a lift here, and people here to get the stuff out of the way, and you can do your proper inspection. So we have to set all that up. But my thing is, in the meantime, what I'd like to do is I would like to have some kind of direction from the board telling me that I can set up a settlement proposal for your approval that essentially is going to release at least $200,000 payable to GDAN. Do a joint check or how you want to do it, we can figure that out. And then we can maybe hold on to the rest of the money, the 174, while we have them do this punch list that is outlined in Tom Tyvik's letter to us here. And while we wait for, we can't do the punch list, we wait for determination of how we're going to do the trust.
I have one question on that.
So that means, the only reason I'm saying is I won't do that now because this is obviously going to take a little while. Then we're going to have snow and then we're not going to. So, but I don't want to have to hold on to the 375. And I don't think we have a $375,000 problem here. I think we have, if we give the $200,000 over GDAN, I think we then take the pressure off of Mid-Hudson. We don't worry about claims so much, and we can maybe have some time to get through this.
My only question to the guys, and I agree with that, Mike has a lift,
Yeah.
he has a truck lift, he can get up there, but the problem is,
Punch list.
the netting alone is 25K. I don't think you can put it back up if you take it.
You can't take that down to get to it.
I think you're gonna lose the netting, that was one of the reasons why they didn't wanna do these coating. So, I'm just letting you know that, so I guess if we go up there.
That's $145,000 to go a long way toward netting and.
Oh, no, I'm not disagreeing with what you're saying with the money, and I have no issue, that I'm staying out.
Yeah.
But what I'm just saying is, it's an expense, and that's, you know what I mean? And it is what it is, if it's not bolted right, it's their fault anyway.
I agree. Yeah.
So, and I agree with that, as far as the money goes, I'm staying out of that, that's not my concern.
They're, okay, yeah, if those things are properly installed, then all this various consequential stuff, like taking netting.
And you got enough money for it.
Yeah, we got enough. We'll give them $200,000, you got $175,000 to get it fixed.
This is all good.
And we work it all through. Okay. So I'd like to be able to see if I can get that done with, Patty.
Okay.
All right? Okay. And then I'll bring something to you folks, and if you're okay with it, you'll vote, say yes, that's okay, Dan, and we can then, somebody else sign it.
Okay.
Right?
Yes.
Okay, but the essence is gonna be trying to get $200,000 out, 175, when we take care of these couple of other issues. Okay?
That sounds good.
Great.
Anything else? All right.
Agree.
I'll be talking to you, Tom. Thank you.
All right, no problem.